in Sessions Trial (POXO), case number 13 of 2017, the appellant faced trial under Section 7 and Section 9 (I) of the Protection of Children from Sexual Offences Act 2012 (hereinafter POXO Act) and Section 354 of the Indian Penal Code 1860 (hereinafter IPC) behind the impugned judgment dated 31/5/2018. The appellant was convicted on 2 counts for the offence under Section 7 of the POXO Act, Section 9 (I) of the POXO Act, and on 2 counts for the offence under Section 354 of the IPC. Consequently, he was sentenced to suffer simple imprisonment of 4 years on each count of the offence under Section 7 of the POXO Act, with fine of Rs 30,000 only, each with default clauses of imprisonment. For the offence under Section 9 (I) of the POXO Act, he was sentenced to undergo simple imprisonment for a period of 5 years and to pay a fine of Rs 40,000 only, also with a default clause of imprisonment on each count of the offence under Section 354 of the IPC. Simple imprisonment for a period of 4 years and fine of Rs 40,000 only. Each default clauses of imprisonment were prescribed. The periods of imprisonment were ordered to run concurrently. Dissatisfied with the impugned judgment and order on sentence, the appellant is before this court contending that in the first instance no evidence determines that the victim was a minor, as her birth certificate was not seized. Secondly, the victim complained of sexual assault on 2 occasions and deposed that when the earlier incident occurred, her brother had also accompanied her to the shop of the appellant for some errand. PW5, her brother, however, did not shed any light on this aspect in his evidence. It was next contended that when the first alleged sexual assault took place, the victim did not disclose it to any person. Neither did she reveal it in her statement under Section 164 of the Code of Criminal Procedure 1973 (for short CRPC) to the learned magistrate and came to light for the first time in her evidence before the court, thereby wrecking of falsity that the evidence of the victim indicates a motive to falsely implicate the appellant, as she had stated that her uncle PW3 and the appellant did not share cordial relations. It was urged that prior to the alleged incident, the victim frequented the shop of the appellant, but no such incident had ever been complained of. That in all likelihood she was tortured by her uncle and aunt to depose against the appellant when she went to record her statement under Section 164 CRPC. That the victim's case is that she had gone to the shop of the appellant at 7 p.m. when in fact his shop closes down at 6 p.m., revealing the intent of PW3 and PW4 to falsely implicate the appellant by sending her after his shop closed. The appellant for his part has clearly denied the allegations made against him in his responses under section 313 CRPC. The medical evidence does not support the prosecution case. Accordingly, the case not having been proved beyond a reasonable doubt, the appellant deserves an acquittal. If you have liked the video, hit the like button and consider subscribing.